time, folks, and when you get close to it, I'll just let you know that you've reached your time. So whenever you're ready, you can begin.
You want some? Okay. We're here because of the damaged goods that happened in the storage bin that we're using. And we discovered going out one day to get some things out that the roof had a hole in it. And a lot of moisture, developed a lot of mold. It had cockroaches, spiders, everything was in the store that destroyed a lot of stuff. And we do have a lot of pictures if you guys want to see. And we just lost stuff. Everything was ate out, molded, and everything. We had to go get masks to even get in there at one time. So the property is destroyed. And then once we reported it, they told us once that they had fixed that roof. And I say maybe a couple weeks later, we went back and the roof was still the same way. It just caused a lot of damage to our goods. So we lost a lot of stuff that we've been saving, a lot of things we've been saving since childhood for the kids. So all that stuff is destroyed now.
I came in there, we came in there in 2006. I came in there in 2006 to purchase a storage bin. And I paid the cash. George Tubbs, he paid, he had his ID because I didn't have my ID. We had been moving and I must have put my ID in the storage. I found my social security card in there, but the ID is still in there. So, and then my eyesight got damaged because I've been in there. George dropped me off early in the morning. I didn't get home until like 7 something, and I had this extreme headache, and I just couldn't keep still. And I called George, and I called my friend up the street, Gwen Collins, and she asked me did I want to go to the hospital, and I said no. I said I couldn't go because I was too big. My headache was too extreme, and so George finally came over with some, I thought I had sinus headache, and George bought me some sinus pills, and I took one, and the headache subsided somewhat. And I just kept walking back and forth, holding my temple, just couldn't keep still. So I finally had a chance to lay down. George woke me up because I dozed off. And when I woke up, he left me, and then he told me to lock the door. And so then the next day, I laid down. The next day, I couldn't see out of my left eye. But when I went to the storage to purchase the storage in 2006, the lady, her name was Tuesday. What nobody else at that storage except me and George and my son. And we had been moving, like I said, all day and all week. And she told me that was the first time I ever rented a storage bin in my life, so I didn't know what to expect. So she told me all I needed was a signature and ID. And so I said, George, I said, you're going to have to sign for the storage bin. I paid the cash. I paid the cash to get a U-Haul truck, and I paid for the storage. He took and had the ID. So,
In other words, what she's saying is that the storage was actually for her, but she didn't have an ID, so I had my ID on me. But I do have a few things in there because we've been together, all this time. So that's her argument right there.
Mr. Tubbs, do you remember? Did you sign a lease for that storage unit?
I don't.
When I say a lease, did you sign something in paper, a rental agreement with the unit?
I can't say it was a lease, but once you get those bins, they do make you sign some stuff. I would say yes. And then later on, we had to do the insurance thing, sign for insurance also, which we had to pay a little more monthly fee.
well, Your Honor, I was in there, getting it together to get the storage rented. You know, like I said, I didn't have no idea. This is the only time I ever rented a storage bin, and he was out in the hallway, you know, somewhere when I did rent it. So she told me, you know, Tuesday told me what to do, and I didn't have it, so I called him in. So maybe he don't remember because of that.
Okay. All right. Is there anything else that you all would like to say at this point?
Yes, I went to the hospital for my eyesight, and my eyesight they told me I had edema. I've been going to get these treatments, you know, and I got receipts here from the stores also, but I had got receipts from the stores, and they said Richard Streisman was on there, and all these different receipts are different names on here. And in 2006, I paid $76. I didn't pay no $80. And they said, and also they had their own keys. They had their own keys and stuff. I mean, we got their lock and key, and we went in there in 2015. Our storage was damaged. Then that's when we noticed it. We went in there to get some my speakers, and I talked to the manager, and I didn't know that was the manager. I don't know anybody. We don't know anybody there. The guy that talked to us, he's no longer there, and we went over there in 2015. That's when we noticed all the rat graffiti and the wetness and the mold, the mildew, and all that. And I have shredded clothes. I have these receipts. These receipts have different signatures on it. Just showing you a few of them. It got different signals on it. There's no Richard on there, and he wasn't around for the signing of the lease. Only person was there is a girl named Tuesday. But anyway, I went to the hospital that second day, and went to the emergency. I got my records. Um, they said that I had edema, but they referred me to the ophthalmologist clinic, and I've been getting eye treatments and to see if they can correct my vision. But I had another case going on with UC Hospital, and I stopped going because the doctor stabbed me in the eye with the needle. So I'm terrified of going now. So I don't want to even go no more. You know, just just made me mad. So I want to say that. And then they said, well, they took and said I had hypertension, but I didn't. I mean, I got the pills that they gave me. They said I had type of blood pressure. I never took these pills. I got all 30 of them in this bottle. And like I said, I got my records and these pills to tell you that I'm not claiming no high blood pressure because I know I don't have it. I just get upset when stuff go wrong, and this is what they did to me. And they told me that I didn't have no rights on the case and went to mediation court. Mediation court was basically about us settling this, but they just told us what they was going to give us, and we waited and finally I showed Scott. I showed him we showed him the evidence of the damage. He barely looked at it. He just asked me how much was Mickey Mouse the talking Mickey Mouse I bought for the kids. And I told him I wasn't sure. I think it was 159. I said I got three of them in there: Big Bird, Teddy Ruxpin, and Mickey Mouse. So I showed him the mold and the mildew on my stuff. And I got a laptop here that will show you all kinds of the damages and everything, but it's frozen.
What she's saying is, all the kids are grown now. It's just that a lot of toys that she got for them when they was kids could have been collector's items. You know, with the Mickey Mouse, the Big Bird, and all that stuff like that. Cause she is the type of person that saves stuff and keep it for years after years. But with all that damage went down with the water and all the bugs and everything went in there, I mean, it just destroyed everything. You know, I'm a military person myself. And I had the old military combat jackets and things like that. Some of the old shirt when I was over in Germany. It just, everything is corroded and rotted out. I just lost a few military stuff, but it's mainly her loss that she lost a lot of stuff. You know, a lot of collector's toys, a lot of the clothes, some of her mom's clothes was there. It's just that we didn't know how long that hole been in that ceiling until we just happened to go there one day to do all the damage.
All right, thank you. Ms. Steele?
Yes, Your Honor.
All right.
Thank you. May it please the court. I'll go over a few of the facts I think that are just worthy of clarifying. It was January of 2006 when Mr. Tubbs signed the agreement to lease this storage space with Wildcat Self-Storage. And just to clarify on that, it's Wildcat Self-Storage then became Simply Self-Storage as a successor in interest to Wildcat. But Mr. Tubbs is the only signatory on that agreement. He also signed a lease addendum, which is also included in the record. The terms under the agreement are that he agrees that there's nothing in the storage unit over $15,000. Total value of the containment of the storage unit is not over $15,000 unless they get written permission to that effect. And if they don't have written permission, it would be held to be no more than that. It's also included in the terms of the agreement in all capital letters, very clearly in there, that the lessee takes the sole risk for the contents of the storage unit, and that insurance is the lessee's responsibility. There was also a lease addendum that was signed on that same day in January of 2006 by Mr. Tubbs, where he agrees and marks off the spot initials and signs that he understands that it's his responsibility to obtain insurance for the contents of the storage unit. There's other provisions also in the lease that are important, in the agreement that are important, including the fact that you warrant that you aren't keeping someone else's property in the unit, that the property in there is solely that of the lessee, and that can't assign the storage unit to people and things like that. Ms. Gibson is not a party to the agreement. She has not signed it anywhere. There's no evidence that she is a party to the agreement, and she essentially admits as much in the letter that they filed on March 21st of 2019 in what appears to be a response to the motion for summary judgment. As pointed out,
Counsel, can I ask a question? Was there anything submitted by Ms. Gibson at the trial level to support her claims for her personal injury?
no, they have filed some. We submitted interrogatories and requests for documents to them. We never got any end requests for admissions. We never received responses to any of that from them. There were some documents that were filed with the court, and included in those documents, there are some medical records that are filed with the court that indicate she was seen for some eye issue. It talks about hypertension, but there's no medical evidence that causally relates it or ties it into anything that associated with this storage unit. There were no experts. They had an expert deadline to identify experts, and there were no experts identified, no reports to that extent provided. So there's, allegations in the complaint that there was this eye issue somehow related to stress. There were copies of medical records filed, but there's no affidavits or anything to go with those to substantiate those or tie anything into the incidents here. And the trial court granted summary judgment based on the clear and unambiguous terms of the agreement. The agreement itself is not in dispute. We've provided a copy with an affidavit that was a copy of the agreement. In the documents that were filed by Mr. Tubbs and Ms. Gibson, there was also a copy of the agreement, the same agreement. And again, Tubbs is the sole lessee. Mr. Tubbs is the sole lessee on that. And there's no question about the provisions in there. And the controlling law is that contracts such as this lease agreement, the rental agreement, even with exculpatory clauses that are in there, are routinely upheld and enforced unless they're shown to be unconscionable or ambiguous. And the case that was cited in our motion for summary judgment, Conkey versus Eldridge, which specifically talks about a storage unit that an individual leased, and they had a lawsuit for things that were stolen out of the storage unit. And ultimately, the court upheld the contract, which was similar in nature to this contract that has releases of claims relative to the contents of the unit. And upheld said that even though it might be a company versus an individual signing the contract, that there's no indication that the contract was unconscionable or it was an adhesion contract, because the customers always have the option to go to some other storage unit, other options and other places that they can go. So they upheld the contract that included provisions of storing your items at your own risk and advising the customer to get insurance in that case. And in this case, we filed our motion for summary judgment. There hasn't been anything provided to contradict or raise questions of fact with respect to the material facts of this case, which are the agreement that Mr. Tubbs is the sole lessee, the provisions in the agreement that the sole lessee is the only one entitled to store property in the unit, and that he takes responsibility for the items in the unit and is responsible to get his own insurance for the actual items in the unit. Also, in the affidavit of Mr. Stratman that was filed, that had the copy of the exhibit, it also clarifies that the storage facility, which was originally Wildcat Storage, then Simply Self Storage, does not have any access to get into the unit at all. The lock and the key are provided by the lessee, and they are the only ones that have access to actually get into the unit. The company does not retain any ability to actually access inside the unit.
I don't believe that. I don't believe that.
There's also one aspect of their appellate brief relates, I believe, to a claim for unjust enrichment. Some of the argument that they've provided is it's just not justice, and they're looking for justice. With respect to any unjust enrichment claim, there's no evidence that there was any benefit to the defendant in this case, and no evidence that the defendant took or retained possession of their property at any time. Mr. Tubbs entered into an agreement for use of the storage unit, and with specific provisions that he was responsible for getting insurance to take care of the contents of the unit, and that he could not store other people's property in the unit, only his own property. And that he obviously allowing someone else to use the unit who is not a party to the lease.
Mr. Tubbs and Ms. Gibson assert that there was a roof issue. Has that roof issue been addressed?
I don't believe there was any specific evidence of any kind raised regarding the alleged roof issue at the trial court level. There were very vague allegations in the complaint about what happened, and there certainly was no evidence, and it wasn't directly addressed because the issue in the motion for summary judgment, which is what we're here on today, had to do with the provisions of the lease agreement and the very specific provisions about that and the risk of loss. I don't believe there are any specific allegations in the complaint about a roof problem or any indication that Simply Self Storage had any knowledge that there was any kind of a roof issue, if there was.
I believe that they asserted that they had reported such and then returned, I think it was about a year later, and found that it was unaddressed.
I think they said that today. I'm not aware that that was addressed at the lower court level at all.
Oh my God.
Can we talk?
All right, just 1 second, I'm sorry, Ms. Gill, are you finished with your argument?
Yes, Your Honor. I think that the trial court properly granted summary judgment based upon the evidence that was provided in the lower court. I know that the review by the court today is de novo and should be based on all of the evidence that was there for the court, for even the lower court. But I believe when you look at the entire record, you will find that the ruling of the trial court was appropriate and defendant was entitled to properly granted summary judgment in its favor. Thank you.
All right, thank you, counsel. All right, Mr. Tubbs, Ms. Gibson, I'll give you a few minutes in rebuttal. Sir, you wanted to say something?
Yes.
Okay.
I knew they were gonna say something like that. It was addressed that they had a hole in that roof. And they did tell us they was gonna go ahead and check it out and get it fixed.
Got pictures.
And we got pictures, document of everything in that storage. You know, all these bugs and stuff, what we gonna go out somewhere and throw a lot of bugs and stuff in there, poke holes in the roof? They know that. They know they had a hole in that roof. That's what started all this. And they did not address that problem right away. Because when we went back later on to see what it done, it still had a hole in it. We even took pictures. We got pictures right here in this laptop we got. She is not telling the truth. That is a flat out lie, what she's saying.
And on top of that, in March.
And were those pictures of the roof condition, was that submitted to the court
Yes,
below us?
yes,
before
Yes,
it
we
came to
even showed
appeal?
it in the mediation, they call it. We even showed them the pictures then.
The Scott on my laptop, but I sent 50 pictures to the courthouse and I sent 50 pictures to the Simply Self Storage now. And and furthermore, I want to state that in March 2020, they went up on their property $2. We paid $2 extra. And I done talked to people that rented. They said they didn't go up their property, but they went up $2 before the court even till it got to this point. I didn't think that was right neither.
All right, well, thank you, folks. Thank you for your arguments this morning. The case is now submitted. The process is now is we will review the entire record from below, and then we will issue a timely decision, which you will receive in the mail. Okay? All right, thank you all for your arguments this morning. Thank you.
Excuse me. Hello? Hello?
Can we say one more thing?
I'm
We're out of time.
Mr. Tubbs, yes, sir. We have to move on to the next case, sir. Thank you very much for coming in, though. Okay?
Thank you.
If you wouldn't mind muting that on your way out, that would be nice. Thank you, sir. All right. Let's let them, there we go. Thank you. All right. Let's move on to the next case then. Next matter on the docket is C2-00015. This is Emily Frank and Lynn Frank versus the Southwest Ohio Regional Transit Authority. Good morning, counsel.
Good morning, Your Honor.
Good morning, Your Honor.
I know we have a number of attorneys on. Who is going to be representing the appellants this morning?
Mike Cusson, Your Honor.
All right, good morning, Mr. Cusson. And
Good
who
morning.
is going to be arguing for the appellees?
Travis Moeller for the appellees.
Thank you, gentlemen. All right, Mr. Cusson, sir, you obviously understand that you have 15 minutes this morning. Would you like to reserve some in rebuttal, sir?
I think he left.
Hold on.
I'll take that as a no.
Well, that's one way. Hold on. Let's see if we can't get Mr. Cusson back on board here. The joys of the new norm, correct?
Correct.
All right, let's see if Mr. Souter's trying to reach Mr. Cusson. He did look like he froze up for a moment.
Yeah.
Mr. Cussin is trying to log back on, so if we'll all just patient for a moment. So I believe Mr. Cussin is going to try and phone it in now, folks. So if we can just be patient, he's having some technical difficulties. So.
Hello?
Mr. Cussin?
Yes, Your Honor.
All right. Can you hear me, sir?
I can hear you. I apologize. I don't know what happened. It says I was in some post-hearing room,
Okay.
and it won't let
All
me
right.
back in on Zoom.
Well, welcome back from the virtual abyss. Sir, as we were talking, that you have 15 minutes this morning. I want to make sure counsel, everyone can hear Mr. Cussin, correct? Is he coming through?
I can hear him fine.
Okay.
Yes, Your Honor.
Mr. Cussin, did you wish to reserve some time in rebuttal, sir?
Yes, 3 minutes, Your Honor.
All right. I will keep your time. When you're ready, sir.
Thank you. Well, now I don't have to tell you if I'm looking off the screen. It's not I'm ignoring you. I'm looking at my larger screen. But this case deals with a serious injury to Emily Frank and the death of Stephen Frank. However, the fact that the accident results in a serious injury or even the death does not mean we simply ignore what the law is. The accident occurred on January 27, 2016. Tyrone Patrick, who had been a bus operator with SORTA for 10 years, was driving southbound on Edwards Road, heading towards Hyde Park Square, while in the course and scope of his employment as a coach operator. When he arrived at the intersection, he stopped at a traffic light due to the red light, and at the same time, Mr. Frank and Miss Frank were walking or heading towards their vehicle. They had stopped at Grader's, picked up a pint or two of ice cream, and were heading home. When the light changed, the Franks began to cross through the crosswalk legally and appropriately from the north side of the square by Grader's down to the south side. At the same time, Mr. Patrick began to pull his coach forward to make a left-hand turn onto Erie. Mr. Patrick had to stop to allow traffic to pass, and once traffic passed, he began to make a left-hand turn when he unfortunately struck the Franks, severely injuring Miss Frank and killing Mr. Frank. Tyrone Patrick is at fault for this accident. There's no dispute as to this. Neither he nor Sorda have ever taken any other position. Mr. Patrick and Sorda acknowledged that he was in the course and scope of his employment at the time of the accident and that he was negligent. The plaintiffs have filed a 9-count complaint alleging against Sorda negligent training, claims for negligent training, entrustment, negligent retention, liability, vicarious liability to the actions of Mr. Patrick, negligent infliction of emotional distress, a survivorship claim, and a wrongful death claim. Against Mr. Patrick, they allege negligent infliction of emotional distress, survivorship, and a wrongful death claim. I believe the parties are all in agreement that Tyrone Patrick was in the course and scope of his employment, that Sorda is a political subdivision in the state of Ohio, and therefore 2744 is applicable. Under 2744-03A6, an employee of a political subdivision is immune from liability for acts or injuries caused by his acts unless they were outside the course and scope of his employment, he or she acted maliciously, in bad faith, or in a wanton, reckless manner, or liabilities expressly imposed by a statute. In the plaintiff's complaint, the plaintiffs make no allegation that Mr. Patrick was outside the course and scope of his employment or that liabilities expressly imposed upon him by statute. They make no allegation he acted maliciously or in bad faith, but that he acted negligently and recklessly.
Well, but Mr. Cussin,
However,
so that's what I want to touch on. So obviously the complaint, they moved to amend to add the recklessness to it. And then my review, the affidavit that was attached on the motion for summary judgment seems to be some discrepancy between that and Mr. Patrick's deposition about whether he was distracted or not. Doesn't that in itself just create an issue of fact on that for the jury to decide?
Well, if he was distracted, does it create a question of fact as to whether he was negligent? There's no question he was negligent. It becomes a question of fact as to whether or not he was reckless. That's the issue. There's no question. We have admitted Mr. Patrick was negligent. We admitted he did not see the plaintiffs as they were in there, in the crosswalk. But there's no evidence he was reckless. He was not speeding. He was not under the influence of any drugs or alcohol. He was not driving recklessly. He did not make a conscious disregard for a known risk or danger. He simply, and again, tragically, did not see the plaintiffs. And there is no evidence that he was acting reckless. That's the position. That's why we believe he is immune, because he was not reckless.
So is it your position that if he was distracted, that would not amount to the culpability of recklessness?
Yes, Your Honor. I mean, and again, I don't, accidents happen regularly. Someone distracted in some way runs into the back of another vehicle. That doesn't make it reckless. He wasn't speeding. He wasn't, again, there simply just is no way. And I believe he testified on multiple occasions in his deposition that he was paying attention. But when he was asked, well, if you were paying attention and you'd seen him, you wouldn't have made that turn. Well, of course he wouldn't have made that turn. The fact is he simply did not see them.
Well, wasn't there also
and
evidence submitted, like an illustration to show where the Franks would have been within the frame of the window of the bus, raising the issue as to whether they were visible, upon looking that they would be visible, basically.
Yes, and I don't think there is any dispute in this case that he should have seen the Franks. I don't believe Mr. Patrick has ever testified or taken the position he shouldn't have seen them. He should have seen them. The fact of the matter, he just simply did not. And again, that leads to his negligence. That does not lead to his recklessness. And that's the issue here, is whether or not there is evidence of recklessness behavior. And recklessness, is, you know, as the courts have defined, is more than mere negligence. It's a conscious choice to ignore and knowing that your actions will result most likely into, you know, an injury. And Mr. Patrick certainly didn't do that in this case, and there's no evidence he did that. As I said, he was paying attention. He pulled forward. He stopped to allow other traffic to pass. He then began to make the left-hand turn. You know, again, he did not follow the SORTA's turn procedures. I will grant you that, and I think that's clear, and that's not been disputed by the parties. But the fact that he doesn't follow our turn procedures does not equate to recklessness. We don't get to set the law. Individuals or companies do not get to set the standard in the law. The law is set by, you know, the Ohio legislature, and courts interpreting that. And the law in this case is you yield the right of way to pedestrians in the crosswalk.
So you're getting
failed to
there
do
to
that.
the issue with regard to the, there was a manual, I can't recall if it was a training manual that had different guidelines in making a turn
Yes,
and
ma'am.
alleged violations of those guidelines. And so do you want to address that part of your argument?
Certainly, ma'am. There is no dispute that we have a manual, that we train our operators, and that we have various turn procedures. And there, again, I don't believe there's a dispute that he didn't take a 90-degree turn. You know, he took a, you know, he did not make a 90-degree turn as directed. He turned and cut it, and again, he violated the procedure. But the fact of the matter is, SORTA doesn't get to tell and set the law, no more than UPS does or any other carrier gets to, or driver gets to set what the law is. This court and other courts have made it very clear that training material and manuals can't set a higher standard of care than what the law is.
You know, and I looked
in
at
this
those
case-
cases, and I, you know, one of those cases is the Yeager case. And, you know, it seems to me that in those cases, the courts had already spoken with regard to a particular scenario. And so they were using the manual to take it out of that scenario, which isn't the case here. The case here is that the argument is that the disregard of the mandates in the manual, and I think there was also some training that had preceded a few weeks before the accident, that went to culpability, specifically because recklessness is defined as conscious that his conduct will, in all probability, result in an injury. So the argument is that it's going to the consciousness that it would result in an injury.
Yes, ma'am, and I
So what
agree
I'm
with
saying
you
is there's
in
no
Yarder.
case out there that says this specific thing is not recklessness, and now they're seeking to use the manual to say it is recklessness.
That's
Which
correct.
Yeager, it went to negligence.
Well, but in negligence, it went to the duty owed, I believe, duty owed with regards to stopping and starting, and those types of injuries and cases, slip and falls when a bus is starting or stopping. In this case, there isn't a case, but there is the law, which is you yield the right of way to pedestrians. That is what he is guilty of violating. He could not be cited, Mr. Patrick could not be cited in any way by any jurisdiction or any officer for violating SORTA's driving manual or turn procedures. What he was cited for, and what he could be cited for, is failing to yield the right of way to a pedestrian in the crosswalk. And so that's what he violated. Now, if SORTA sits there and says, well, in order to make that turn, you have to do something different than anybody else, or even if the Ohio driving manual says you should make a turn in a different manner, you still aren't violating, you're not violating a law in that. And that's what the courts, I think, have been quite clear on, is that they can't change and set forth the liability because of training materials.
So are you saying that failure to yield only goes to negligence and never goes to recklessness?
No, ma'am, but I think that's that's the statute you violate. Then you have to look at his actions, and his actions are, what, did he make a conscious choice to not yield to the right of way? Did he see the Franks and to say, I think I can make it before they, without hitting them, before they get into my way? Can I do this? Did he consciously get on the bus and decide, you know what, I'm intoxicated, but I'm going to drive anyways? Or I'm going to be driving as I'm sitting here texting. Or I'm going to take this turn, even though the speed limit's 35, I'm going to take the turn at 40 rather than the 15 to 20 miles an hour he was going. That's the recklessness, is to the actions that he's taking.
Let me ask you, Mr. Cusson, though, but isn't that a question of fact then?
If they present evidence, but in the evidence, the only thing that they presented as evidence to argue that he was reckless was that he violated SORTA's rules and regulations, which the courts have said that's not a duty that you can violate. The duty is what the law is. SORTA can't sit there and say, well, SORTA said.
The Anderson case has some interesting language that talks about how these things could be used in order to establish culpability.
Okay, I didn't know. I don't know if you wanted me to comment on that or there was a question.
You can take it however you please.
Well, again, respectfully, I think the cases are clear that you can look at them, but they aren't the duty. And that's what you're looking at here, is he violated the duty and whether or not his actions rise to the level of a conscious disregard. And respectfully, I don't believe there's any evidence that he consciously disregarded known facts or risks. The evidence, I think, is quite clear. Mr. Patrick did not see them and caused this accident. With regards to, I'm going to move on. Thank you.
Sir, you've reached your time if you want to save rebuttal time, Mr. Cusson.
Thank you, I will.
All right, thank you. Mr. Mueller?
Thank you, Your Honors. I appreciate it. I appreciate you accommodating us via Zoom so we can get this oral argument done and move the case forward. May it please the court, my name is Travis Mueller and I represent the Frank family. I'll start on a statement that Mr. Cusson made, which was that there's no evidence that Mr. Patrick was acting reckless. The record is, they even went as far as saying the record was devoid of any evidence. The record is replete. There's evidence all over the place. In keeping in mind that the standard is what SORTA has to prove is that no reasonable person could conclude that defendant Tyrone Patrick was reckless in his operation of the bus. And that's in viewing the facts in the light most favorable to the plaintiffs. With that said, I want to talk to you about the night that this incident occurred. Mr. Frank and his daughter, Emily, had gone to dinner and then went to Grader's to purchase some ice cream. They purchased their ice cream, took it to go. They were waiting on the corner of Erie and Edwards when the bus pulled up. The evidence that all of this was on the bus video. The evidence shows that Mr. and Mrs. Frank were visible at that corner to Tyrone Patrick had he bothered to look for almost 30 seconds.
Well, apparently there's no issue of fact as to whether they were visible, according to the appellant. According to the appellant's argument, there was no fact as to whether the Franks were visible.
I agree. I believe Mr. Patrick even testified, had he been paying any attention at all, he would have and should have seen them. He admitted that the most likely reason he did not see them was because he was distracted. Prior to making this turn, he had stopped at Wendy's and had ordered some chili, and he was either eating the chili or disposing of it or doing something with it while that bus was in motion and pulling into the intersection. While he was supposed to be keeping an eye out for pedestrians, he was distracted. So much so that he testified, and this is evidence of record, that had he been paying any attention at all, he would have and should have seen the Franks. But he never saw them, despite them being there for almost 30 seconds.
Well, it seems like the argument this morning is that regardless that only goes to negligence and it doesn't go to recklessness?
Well, and there's, and I'm just beginning on the evidence of recklessness. Mr. Patrick pled guilty to vehicular homicide for his role in this case. This wasn't some mere accident. This wasn't mere negligence.
Is that part of the record?
It is, Your Honor. He testified to that in his deposition, and it was in our motion for summary judgment and in the appellate brief, or appellee brief. Mr. T.J. Thorne, the vice president of safety and security for SORTA, testified in his deposition that defendant Patrick's operation of the bus at night in an intersection which he knew to be a busy intersection at Hyde Park with lots of bars and restaurants at 13 miles an hour, which is almost three times what SORTA says you should make a left turn, was reckless conduct. That's the testimony of their vice president of safety and security. Mr. Frank was hit in the crosswalk by defendant Patrick without having ever seen him. And Mr. Patrick was so distracted that he didn't bring the bus to a stop for 9.4 seconds after hitting the Franks. 9.4 seconds. Mr. Frank was hit in the crosswalk and either thrown or dragged 30 to 35 feet. And because that bus kept moving, that bus ran over Mr. Frank's head and torso 30 to 35 feet from the point of impact because Mr. Patrick was so distracted. He couldn't even bring the bus to a stop in a reasonable time. The mandatory turn procedures, which Mr. Patrick was trained on a mere 3 weeks before this, his supervisor, Alvin Wyatt, said, look, we train all of our bus drivers, and he said that he specifically trained Mr. Patrick of the policy even says if you don't follow these mandatory turn procedures, devastating consequences can follow, those being severe pedestrian injury or death. And Mr. Patrick testified that he was aware of that risk, and that he was aware that if he didn't follow the mandatory turn procedures, that those devastating consequences could happen. And he testified that on the night of this incident, he was aware of that risk and that he proceeded to make that turn while violating almost all of those mandatory turn procedures. If the definition, which we agree on, is a conscious disregard or indifference to a known or obvious risk of harm to another that is unreasonable under the circumstances, this is the epitome of reckless conduct. And it cannot be said that no reasonable person under these facts could conclude that defendant Patrick was not reckless given these facts. The evidence is overwhelming.
Let me ask you, Mr. Cousins was his response was, so what? It's not reckless because safety violations they're just rules. They're not statutes or anything else like that. And so unless he was reckless in violating one of those rules, it doesn't matter. How do you respond to that argument? Well,
and Judge Zayas pointed to this in Mr. Cousins' argument, which is Mr. Cousins says the mandatory turn procedures play no role, but only Mr. Cousins says that. The Supreme Court in Anderson, and this court in Pitzer v. City of Blue Ash, has said that violations of departmental policies are relevant to the degree of culpability. They are relevant as to whether Mr. Patrick was reckless. They're relevant to his knowledge of the risk. He was trained, he was told, he knew that there was this risk. And he made this turn in violation of that policy anyways. That's reckless conduct. And the Supreme Court says that those policies are relevant on that issue. And this court has said that in Pitzer v. City of Blue Ash, that those policies are relevant on the issue.
What about the number of accidents that he also had supposedly had? I saw that there seemed to be some discrepancy about the number and how. I mean, is that relevant? Is that something that the court should look to as to recklessness?
Well, there's no question that Mr. Patrick had a dismal, horrible, shocking, frankly, accident record. This was either his 40th or 39th accident, depending on who you ask, while driving a sort of bus. He has an operator accident record where they're all listed. And that fact is relevant to a couple of issues. One, it's relevant to the reckless conduct on the day of the incident. And it's also relevant to defendant SORTA, the plaintiff's direct causes of action against SORTA for their failure to terminate defendant Patrick long before this incident happened. And that brings me to assignments of error number 1 and 3, which are interrelated. And this whole issue of the plaintiff's amended complaint, I'll address. It is a red herring in this whole thing. And frankly, I wish that it wasn't filed because it wasn't necessary. And now they're leveraging it to complicate matters. But their SORTA's arguments on the issue of the amended complaint are only based upon their misunderstanding and misbelief that the plaintiff's amended complaint alleged a completely new cause of action. That is simply not true. The plaintiff's complaint and amended complaint all allege the same causes of action. Recklessness against Tyrone Patrick under 2744.03A6, vicarious liability for the negligent operation of the bus under 2744.02B1, and then the direct causes of action for their failure to terminate Mr. Patrick under 2744.02B2, which is an exception to the immunity. This court's well aware of the 3-tier analysis. They start with immunity.
I mean, even if it wasn't asserting a new cause of action, the reality is that you could not reach Patrick without asserting recklessness. Well, no. So recklessness was asserted against defendant Patrick. Oh, that's right. That's right.
The issue was recklessness asserted against SORTA for their failure to terminate Mr. Patrick. And the exception to immunity that we alleged was 2744.02B2, which says that a political subdivision is liable for the negligent performance of acts by their employees with respect to a proprietary function. It's undisputed that a bus line and a transit authority is a proprietary function. So SORTA complains that by adding reckless to the allegations against them, that we've added this new cause of action, which is not true. We added our allegations, and our obligation is to have sufficient allegations to put them within an exception to immunity, which we did. That's 2744.02B2, negligent performance of a proprietary function.
And if there's an issue of adding a new cause of action, that really goes to whether it prejudiced them. But there's other things to consider in determining whether there was prejudice. One would be timing.
That is all correct. But if it didn't change anything, and the timing was, we asked for depositions of the management personnel of SORTA in September. Because of scheduling issues, we got to them, I believe, in early November. They testified that based upon his operator accident record, Mr. Patrick should have been fired all the way back in the 2008-2009 timeframe for a series of rear-end accidents that he caused in the bus. So we amended the complaint shortly thereafter. So I believe that it was as timely as it could have been. But I think the larger point, Your Honor, is that the issue of recklessness only comes into play if defendant SORTA can establish that they're entitled to rely on one of the affirmative defenses in 2744.03. All the case law says that if the plaintiff shows that one of the exceptions apply to remove immunity, which we did under the political negligent performance of a political subdivision, the political subdivision has the burden of showing that one of the defenses from 2744.03 applies. That's Dove v. Beechwood, cited in our brief, Alkus v. Bainbridge. And frankly, if you look on page 13 of SORTA's policy, they say if an exception applies, the burden shifts to the political subdivision to to demonstrate that a 2744.03 defense applies. That's a quote out of their brief. The Supreme Court has said that the immunity defenses in 2744.03 are affirmative defenses which the political subdivision must assert. The courts have said that the 2744.03, that third tier of the analysis, that especially the discretionary defenses that SORTA now relies upon, do not create a cause of action or establish liability.
I'm not sure if this is what you're saying, so if you can just let me know whether I'm understanding this correctly. Are you saying that even if the complaint had not been amended, that it would have had, it basically would have no effect because it's an affirmative defense, it had to be asserted by SORTA, and then at that point, then you would address whether recklessness has been, whether the culpability has raised to recklessness or not on behalf of SORTA?
That's exactly right, because the exception says that SORTA is liable for the negligence in the proprietary function. They have to then prove, their defense that they have to allege and prove is that their actions were discretionary. And then if they prove that, then they have to show that they were not reckless. And in its motion for summary judgment, SORTA did not cite a single fact or any evidence or even argument that its failure to fire Tyrone Patrick was discretionary, thereby entitling it to a 274403 defense. In fact, it didn't even allege that defense in its answer. Instead, SORTA argued that because the plaintiff did not use the word reckless in their complaint as to SORTA's conduct, that it is immune pursuant to the 274403A5, which is what they call a discretionary defense. So the point is, Your Honor, that they've put the cart before the horse, that before they're entitled to that defense, they have to show that their conduct was discretionary. And Drescher v. Burt says that SORTA bears the initial burden of citing record evidence that demonstrates an absence of a genuine issue of material fact, that they are entitled to the defense. They cited no evidence. They just said, you didn't say reckless, therefore we're immune, which is not the case. In Vance v. Jefferson Local Schools, the 11th District said that in the summary judgment context, when an affirmative defense is raised, a political subdivision in its own motion has its initial burden of first presenting some evidence that it's entitled or would tend to prove the existence of the underlying facts upon which the defense is based. And if they don't meet that.
And I'd like to address that because in the summary judgment, wouldn't SORTA first have to deal with .02 before getting to .03?
Yes, Your Honor. They would first have to put on some evidence that they weren't negligent to deal with in the performance of the proprietary function. And then if they are negligent, then they have to show the facts that say we're entitled, even if we were negligent, we're entitled to the affirmative discretionary defense in 274403A3 and A5. And because they didn't cite any evidence, they never cited a single piece of evidence regarding their decision to terminate or not to terminate Defendant Patrick despite his horrible accident record. They just assumed they were entitled to the discretionary defenses, which puts the cart before the horse, like I said. And if they don't cite any evidence, the plaintiff doesn't have the reciprocal obligation to cite contrary evidence. This very scenario was recently before the 9th District in the case of Elias v. City of Akron. It's almost identical. The city argued that it was immune from liability unless the plaintiff proves that the city employees exercised their discretion and that they were not reckless. The court, the 9th District said that the city misunderstood its dual burdens, because it was both the party asserting the affirmative defense and the party moving for summary judgment, that they bared the burden.
But what I'm saying is, don't they have to address .02 first? And you see on the negligent training and entrustment, that negligence there doesn't go to Patrick. It goes elsewhere.
That's
And
correct.
so although they conceded negligence as to Patrick, there's still a negligence that still needs to be addressed separate to the negligence of Patrick. Are you following me?
I am following you, and
Okay.
I agree that they did not address their own negligence. They didn't cite any facts on their own negligence or their failure to fire defendant Patrick. Period. The issue just wasn't raised. They just argued they're entitled to the 274403 defense without citing any facts in the motion for summary judgment context, which Drescher v. Burt, Vance v. Jefferson, and Elias v. City of Akron all say if you don't cite any facts showing you're entitled to the defense, you lose. You have to show that you're entitled to the defense. You can't just assume that your actions were discretionary. And that's exactly what the court in Elias found. And they said the city failed to cite any relevant authority or present any meaningful argument to support the contention that the city's actions were a proper exercise of discretion. And that, therefore, summary judgment was properly denied in that case, and it was properly denied in our case.
Mr. Moeller, I'm going to have to stop you, sir. You've gone over your time. Thank you for your argument. Mr. Cusson, you still have your 3 minutes, sir.
I'll be quick. I'll try to address a few things. First of all, Mr. Moeller stated that Mr. Patrick was charged with homicide, vehicular homicide. That's correct. He was charged with negligent behavior. The vehicular homicide is a negligence claim. Second, he talked about Mr. Patrick's accident history. Mr. Patrick's deposition was taken, and Mr. Moeller said to him on 2 occasions, pages 15 and 17, that he has counted the accidents that Mr. Patrick had been involved in, and this would have been his 10th. There are 38 incidents in his accident file, but that could be anybody from slipping and falling, somebody running into the bus. Those aren't accidents that he caused or created. Those are something that he's been involved in over 10 years as operating as a bus driver. With regards to SORTA, the liability, SORTA does not dispute it is liable to the plaintiffs under 274402B1. Mr. Patrick was negligent, we believe, therefore he was immune, and therefore his negligence passes on to us. It's the additional attempts by the plaintiffs on negligent training, entrustment, retention, infliction of emotional distress, and the vicarious liability, which they are not entitled to bring a cause against us. First of all, they argue that we had the burden. There's no question we have a burden to prove or argue an affirmative defense exists and is applicable. But they didn't even raise those issues. They did not raise reckless conduct on behalf of SORTA. So it wasn't even something that we could, they want us to put the affirmative defense before they even made the allegation that SORTA was reckless, willful, or wanton in the manner in which it operated. There is discretion on behalf of, there is immunity for discretionary acts on behalf of political subdivisions in the way in which we handle our personnel and that type of stuff. And so in this case, they asserted we were negligent. We don't have to prove the negligent, they don't get the claim. So there's no reason to put forth evidence as to whether or not we were negligent. If we admit we were negligent, they still do not have a cause of action. And I would point out, I've filed the McConnell versus Dudley case, which was just decided last year by the Supreme Court. It was a unanimous decision, which deals directly with this situation. And they said that in this type of situation, that case was an officer was involved in an accident, police officer was involved in an accident. The plaintiffs alleged not only negligence, but willful, wanton, and reckless behavior on behalf of the township that employed him for their training, hiring, and retaining of the officer involved. And in that case, the Supreme Court said that the exception to immunity under 274402B1, which allows political subdivisions to be liable for the negligent acts of their employees while operating a motor vehicle, does not cause or create a cause of action or an exception for the negligent hiring, training, or supervising of its employees. So in this case, under McDonnell, whether we were negligent or not, there is no liability. I think I got it all in.
All right. Thank you,
Your Honor,
counsel.
Your Honor, and I apologize, this is somewhat unorthodox, but may I have an opportunity to address the McConnell v. Dudley decision? It wasn't raised by Mr. Cusson in his initial argument, and it wasn't cited in his brief. He just filed it with the court a couple days ago. And I think that I ought to have an opportunity, now that he's raised in his rebuttal, to at least take 1 minute to address it.
Mr. Cusson, do you have any objection to that?
It was only raised in rebuttal because I didn't have time, but I have no objection.
All right, thank you. Go ahead, Mr. Mullen. We'll give you a minute.
Thank you, Your Honor. The McConnell case that he references was a police officer that was involved in a motor vehicle accident during an emergency call. And the operation of a police department is a governmental function. Therefore, the issue of 2744.02B2, which is the exception we rely on for the negligence, the direct negligence of SORTA, which is with respect to proprietary function, was never an issue in that case. I spoke to the lawyer that argued the case. It was never raised. It was never an issue. It has no bearing on this case. Of course, in that particular case, the governmental function, the court found that under B1, you can't allege a negligent training or negligent retention claim, but it never addressed B2. It has no application to this case. And I hope that I've kept it within the 1 minute. Thank you, Your Honor, for allowing me to address that.
All right. Thank you, counsel. Case now submitted. Thank you for your arguments this morning. Tough case. Appreciate your arguments, and we will issue a timely decision.
Thank you, Your Honor. I appreciate it.
Thank you.
Thank you.